think so.
State jail.
Great.
Stand by. Let me see if it's
Enhanced.
not.
I don't think it is.
It's just a state jail credit card use. And then unlawful possession of a firearm, which I guess is going to be represented in none of this.
It must be a UCW misdemeanor.
And see, yeah, this is.
Oh, is that one of the allegations?
It's December 4th, 2023 allegation, but you have an indictment handed up on January 24th, which alleges the first degree felony of aggravated assault resulting in paralysis, but that's not alleged.
Right.
Nor is the other indictment also indicted in January of engaging in organized criminal activity of third degree felony. Do y'all intend to amend?
It's only a state jail, and I mean he's asking for a trial on those underlying charges anyway. So
yeah, I know, but we generally move forward on a motion to revoke probation if it doesn't have anything to do with the trial.
Are they're administrative in that motion to revoke?
Yeah.
Curfew and a couple other things.
Location, yeah, it's a curfew, 4:45 a.m.
Which my recall is, Judge, all that is related to being at the scene where this aggravated assault occurred. So we can amend, but I just don't know that it's totally necessary. We're ready to go on the trial.
How much back time does he have credit on this 41605, please? What are his bonds on these new cases? Do we know?
I'll check while
okay. I need to know that, please, too. Y'all want a trial, right, on this?
Yes,
is that right?
Yes, sure. Yes.
265 days.
Okay, thank you.
Yes, sir. And then the bonds.
What is it on 2449?
$35,000. And then on 0050, it is $15,000.
How much?
35,000 on the ag assault, 15,000 on the engaging.
Wow.
And I will tell you, Judge, that I think I believe that those bond amounts were based on the charge originally being, I think, an aggravated assault. At that time, they did not know that there was medical permanent paralysis.
Well, but until y'all do something, I don't know what to do about it. I can't handle with it.
I understand.
Really, I don't. It's up to y'all, but we're going to go to trial on this, but what's the bond on the motion to revoke probation, which is 23-41605?
There is no bond.
There is no
We're
bond?
holding him without a bond.
Well, it's a deferred probation, isn't it?
Yes, I would request, that's one thing we're going to do, is request a bond on that at least. It's deferred state jail pay, sure.
I know, but you're entitled to.
Yeah, absolutely.
You want to have it right now?
Yes, I would like to have a bond. So
Do you have the report?
Yeah, I've read it. It's a bad situation, of course, on that one. He's accused of first degree felony while on probation here. And it also alleges here, though, that this was in the course of an attempt to rob someone, which is, this is alleged as a first degree felony, but
Could have been
a capital murder
yes, sir.
could have been presented to a grand jury under these circumstances. It wasn't, it still could, but as it states that the victim was sitting in a vehicle at an apartment complex when the defendant and others attempted to rob him and another occupant, but were unsuccessful. As the vehicle sped off, the subjects opened fire, and the victim was shot. And he is apparently paraplegic now. He's paralyzed from the waist down.
Yes, sir.
So that's why this aggravated assault, a second degree felony, is enhanced because of the seriousness of the damages or the injury to a first degree felony. So the defendant's looking at up to life in prison. But this clearly says this was done in the course of a robbery, which is defined as capital murder, as under the law. But that's something for a grand jury to officially accuse. So this court is certainly not reducing any bonds, but there is no bond on this motion, 23-41605.
Correct, Judge.
You're asking for a bond on this?
Yes, Your
What are you asking for?
Honor. Your Honor, since this is a state jail case.
I don't understand, but the reason is still.
Well, this case itself, I would ask for 5,000 since it's a state jail case. That's a reasonable amount for a state jail case. And I understand the other cases are first degree much harsher, but I'm not asking for a bond reduction for those cases. I'm asking for a bond to be set in this case, which is a motion of probation. Where he was
And what's the state asking for?
Well, Judge, even though the aggravated assault is not included in this motion to revoke, the underlying facts concerning where he was at the time are, and obviously it's indicted. I mean, I think that the bond should be sufficient enough to take into account the violent acts that this individual is accused of committing while on probation. And then also
and what is the amount you're thinking is appropriate under law?
250,000.
Okay. What about 24 CR 49, the first degree felony?
I can file a bond motion for that, or I can make one here in
Go
open
ahead.
court. I would make a bond motion to increase that bond. I truly believe that the bond was set based on the fact that it was only referred as an aggravated assault at the time, a second degree felony. It is clearly not. We've subpoenaed medical records to prove this individual's paralysis, and he is most certainly in a wheelchair.
Well, the grand jury indicted this in 2 months later after the event.
Yes, sir.
On 2449, please, the bond,
It's 35,000.
when was that set?
Right. So, Judge, I will note that the detective's invest is an investigation for aggravated assault with a deadly weapon. It was not until after this original warrant went out that it was determined that the victim had suffered permanent paralysis.
Okay, it looks like the magistrate set these on January 27th. 15,000 and 35,000 for the third degree and first degree felonies respectively.
I've got a PC affidavit dated January 2nd, and you say the magistrate's order is January.
27,
Okay.
9/28.
And does it show which magistrate?
I can't read them.
Yeah.
I can't read their signature. It's a lawyer.
You know, I would argue that the indictment was before that.
Yeah, I know. Yeah, I just don't know what this person had to deal with as far as considering, and also stand by this motion to revoke probation was not filed until after this too.
Sure.
And I can't say that the magistrate was aware the defendant was on deferred or unadjudicated probation for felony at the time.
It looks like Judge Hughes.
Hughes? Well, what are you asking for? The,
250,000.
on what?
Well,
No, which one?
on the first degree, I believe that is an appropriate amount.
What, and the new case?
Yes, sir. That's the one.
Well, but the new case is not, the new case is a motion to revoke probation on a stage F felony.
I'm sorry.
Talking about this one, the first degree felony is a case. There is no bond yet on the motion to revoke stage F felony. There is a bond set. Are you asking for the court to set a high bond on the motion to revoke probation and raise the bond on the first degree felony?
Yes.
Anything else from the
I would argue that the new case, I'm sorry, the motion for probation case is not indicative to rate to high bond on that one. It is a stage jail case for credit card abuse. I would still argue for a low bond on that one. As far as the other cases, we were originally going to ask for a bond reduction. Within the hearing court, we decided we would rather just keep at the current set rate. My client is unable to bond out on those, but we would ask the court not to raise on the two new cases and to set the bond on the motion to revoke at 5,000.
Okay.
And Judge, before you make your findings, I
Yes.
do just want to make sure you have that public report for the aggravated assault case in your file, that you've been able to review it.
The public report.
Yeah, the public safety report.
Huh?
The public safety report, or whatever it is we have to consider.
Well, that should have been with the underlying offenses first. I'm gonna have to get a public safety report. I don't have one
Okay.
here, but the court will defer until it gets that.
Okay.
Then we will let everybody know what the
I'll be
decision is.
available. I will be in next week as a lot of people.
All right.
Sadly, but I'll be available
But
this week.
the court is going to be inclined to increase the bond in the first degree felony, and the motion to revoke probation is going to be set higher than what is generally set for state jail felonies, since this is a state jail felony that has a motion to revoke probation, which is a most serious allegation. But the public safety report needs to be considered before I can do that, as we all know, and it's supposed to be considered when the bonds are set originally as planned.
Wait to that to determine our next step.
Thank you. That's what I'll let you know, but I will let you know today, maybe this before noon.
I'll be here.
Okay, thank you. I have did you see the public safety report? Here, I want you to look at it, but which is here.
Sure.
What rulings did I make already on him?
You haven't.
You haven't made any official rulings. You gave us what you thought you were going to do, and officially give it to you.
And-
This is different.
Oh,
No, this is the.
this is a different one.
This is the one, that Sonny Eckert was asking for a bond increase on the new aggravated assault case.
We were asking for not to increase and just extend the bond on the.
Okay, I did not make any findings yet.
Did not, 'cause you were waiting to get the report.
Okay, I have received in Jason Arkley's cases, 23 CR 41605. That's a state jail felony that involves a motion to revoke probation. In that motion to revoke probation, it is alleged the defendant on or about December 4th of 2023 committed the offense of unlawful possession of a firearm by a felon. And a new case of first degree felony of aggravated assault with a weapon involving the result of paralysis to the victim by shooting the victim with a firearm in 24 CR 49, a first degree felony. And also the defendant has been charged in 24 CR 50, the third degree felony of engaging in organized criminal activity. That is an offense alleging on or about November 28th of 2022, committing the offenses of burglary of a vehicle, burglary of a building, theft of a firearm, credit card abuse, all rolled up into that indictment of engaging in organized criminal activity. And I guess he was, well, that took a long time to process through because that indictment doesn't come down until, is not handed down until January 24th of 2024, when 24 CR 49 is indicted as well, alleging on or about November 30th, 2023, the defendant committed the first degree felony of aggravated assault resulting in paralysis of the victim. All right, so a state on that was, I can't, Mike Laird, were you up here on
No,
this?
this was Mr. Eckert was up here on this one.
Okay. What were, okay, I now have the public safety report, which
This is on.
is reviewed a 3-page report, and the defense has received a copy of this as well. And the court will note that one offense, 24 CR 50, engaging in organized criminal activity, that is alleged to have been committed prior to the defendant's probation was granted in the state jail felony. That for someone was not indicted until after the defendant, well, no, it was, yeah, it was indicted after the defendant was placed on probation for a June 21st, 23 event. But the indictment alleges that this was November 28th, 2022, which engaging in organized criminal activity, which were preceded the date of the defendant's probation.
Right.
However, 24 CR 49 alleges that the defendant committed this first degree felony 5 months after he was placed on probation for the state jail felony of credit or debit card. And And so those are, it's a most serious offense, and it's going to have significant impact on the court's decision in bond in this case. Anything state wants to add?
Mayor, I think the charge speaks for itself as far as the new charge.
Defense, what are you asking?
Your Honor, we were asking to not raise the bonds on the two new cases that are already set. The magistrate said it after they were indicted, so they've already been set. And on the motion to revoke probation, we're asking for 5,000, which I think is a fair, adequate number for a state jail felony revocation of a deferred probation.
Okay. Once again, Article 15.17 and related court decisions are the guideposts, 15.17, which is the Code of Criminal Procedure, or not 15, Article 17.15, the Code of Criminal Procedure in Texas set forth the rules for setting the amount of bond. Also, court decisions, including Smith versus Spade, 829 Southwest 2nd, 885 out of Houston District, 1st District Court of Appeals, Houston. Ex parte Watson, 940 Southwest 2nd, 733, Texarkana Appeals Court of Texas. Ex parte Green, 940 Southwest 2nd, 799 and 1997. Court of Appeals case out of El Paso, and ex parte Ruback, or UBAC, 611 Southwest 2nd, 848, Texas Court of Criminal Appeals, the highest court in Texas, are all court decisions that add not only the nature of the offense, whether it involves violence, whether the future safety of a victim or law enforcement or the community are considered with those statutory determinations under Article 17.15 included in Bell factors, or court decisions including prior criminal record, whether the defendant has previously complied with bond conditions, aggravating factors in the charged offenses. And here in this case, the defendant is on bond for a felony offense, and he's on probation for a felony offense in clause number 23-41605, that being credit card or debit card abuse, but it's still a felony offense. He was placed on probation June 21st of 2023, and 5 months later, it is alleged that he commits the first-degree felony of aggravated assault with a deadly weapon. And the court reviewed earlier the facts on this case with the parties, where a person was shot and the defendant and others were attempting to rob the occupants of a vehicle. And as the vehicle sped off from the robbery, the three subjects opened fire. The victim, including the defendant who was involved in the robbery as one of the robbers, the complainant was shot and is a paraplegic, is apparently paralyzed from the waist down. So this aggravated assault was enhanced to a first-degree felony. But again, that was committed just months after the defendant was placed on probation. prior to the defendant being placed on probation in cause number 23-41605. He is alleged by the grand jury to have committed on or about November 28th, 2022, the third-degree felony of engaging in organized criminal activity by collaborating with others to commit offenses of burglaries of vehicles, burglaries of a building, theft of a firearm, credit card abuse. And that was an indictment handed up by the grand jury on January 24th, 2024. Although the offense had occurred over a year, about a year and 3 months prior to the grand jury. All right. Did state want to add anything about amounts we were talking about?
No, Your Honor.
All right. Then here's what the court's going to do. The motion to revoke probation, his bond is $100,000 for that. Even though it's a state jail felony, the violation is most aggravated. One of the violations is it results in permanent injuries to someone and life-threatening as well. The 24 CR 49, that is the first-degree felony of aggravated assault with a deadly weapon. $250,000 is the bond on that case. And the engaging in organized criminal activity, $50,000 on that case in 24 CR 50. Those are the bonds. If the defendant is able to make bonds, you must be placed in home confinement. You will have a GPS device as a condition of bond. You can only leave the home for work or food or necessary medical needs, and that's in the most direct route possible to and from your home. Do you understand what has happened today? Yes. Mr. West, go ahead. What's next?
The only thing is set it for trial, Your Honor, and determine whether I stay on or if you would like another attorney to get this on trial.
You want this set for trial, right? Yes. Well, we have a motion to revoke probation. Mike, on behalf, I'm kind of, there's a motion to revoke probation on that state jail felony.
I'd rather set it for trial, Judge, instead of wasting all those resources.
Yeah, I think what we'll do is generally I like to hear the motions to revoke probation. In this circumstance, let's move this for trial on the first degree felony.
Yes, sir.
First, okay? All right. Anything else on that? No, that is all on that case.
Whether he wants to keep me as attorney or get with
Yeah.
attorneys. It's up to him.
Mr. West is a fine trial lawyer. We're going to set this for trial. It probably gets to trial quicker if you agreed to release him. And then the next person on the trial docket wheel, who are all competent lawyers, experienced lawyers that the judge, West and I, make sure that they're competent to try cases. They're good lawyers too. It would go to trial quicker probably, but the question is, he's been assigned to you and you can keep him unless you are asking me to replace him, but that's your call.
Okay.
All right, he's a fine lawyer. We'll set that for trial. He'll continue to be your attorney. Thank you. And